Mike, you good? Okay. Welcome, everyone, to today's regularly scheduled and final Metropolitan Short-Term Rental Appeals Board meeting for 2024.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for its regularly scheduled meeting of December the 18th, 2024. I am Short-Term Rental Property Chief Bonnie L. McBroom III, and I'll be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent so as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board and their rules provide for cases without opposition 5 minutes total for the appellant, including members of the public speaking in support of the appeal, to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal 10 minutes for their total for their presentation and rebuttal of the opposition's presentation. The appellant must reserve a portion of the allotted 10 minutes for their rebuttal. For members of the public speaking in opposition, 10 minutes is provided. This is 10 minutes total for all speakers combined, not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. You may send the comments to strboard@nashville.gov. Documentation supporters or opponents wish to provide the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through the cases set for public hearing today, and after both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on cases before us today under the provisions outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board be present to constitute a quorum. The board rules require a majority vote in the affirmative of the members present to grant the appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggrieved party may, within 60 days of the entry of an order stating the decision of the board resulting from an appeal hearing, appeal the finding of the board under common law of certiorari in accordance with TCA 27-9-101 etc. to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you applied. It should be noted that a permit must be obtained within 2 years for the board approval to remain valid. I submit that all cases have been filed in proper order. The appellants have been notified by certified mail as required by the code, and all affected property owners have been notified, and legal notification sign requirements have been met as required by the code. Chairman Caputo, before we move on to the cases, I believe you have an announcement.
We do. And I also wanted to touch on the cases that we have for us today and make sure everyone is here for the right case. First thing I wanted to share with everyone is, since we had our last meeting in November, I guess in October, I think we canceled last month, there has been a new law signed by Freddie O'Connell, by the mayor, that no longer allows the council members sitting on appeals boards, not just ours, this is applicable across the city, across the county. The council members who sit on the board are no longer voting members. So we need to keep that in mind when we're going to have an issue with a quorum, that if we have 4 voting members, only 3 of us plus Sean are here, we haven't reached a quorum. So that's something to keep in mind. That'll also explain why Councilmember Parker does not participate in voting today, but he's here to represent the council and to share his expertise and guidance and all of the above. Anything I should add to that? No? Good. And then quickly, let's just review that we're hearing one case today, and that would be STR 2024-33, located at 2688 Miami Avenue. There were 2 other cases originally on the docket. Let's see, 917 Deer Vale, If anyone is here on that case has been withdrawn. So I don't want to keep you unnecessarily. Or if anyone is here about 1030 Scovell Street, that case has been deferred to the next meeting. Okay, so if anyone's here about, Charles Anka or Anka Charles or Angela Cooper and Stephen Cropper's cases, those cases are not going to be heard today. Okay? So everyone here is interested in Miami Avenue? Okay. Turn out.
Chair Caputo,
Yes.
at this time would like to recognize any elected officials, and I do know that we have Mr. Max Caskey here representing Councilmember Cuban, and he would like to address the board.
Terrific.
Well, hello, everyone. I hope you're all doing well today. Max Caskey here on behalf of District 19 Councilmember Jacob Coupin. Our item actually got deferred, so I will be seeing you next meeting, or maybe the council member. So thank you so much.
Thanks so much. Happy holidays.
All right, Chairman, is there anything else we need to cover before we go to the cases?
I think we've covered it all. Unless I am corrected by anyone, are we good to go? All right.
All right, we'll go to our first case, 2024-033 is the appellant present. And obviously, we do have opposition. Therefore,
That perhaps people are here in support. Let's see if we have opposition or support. Could you raise your hand if you're here in opposition to this case? Terrific. And could you raise your hand if you're here in support of this case? Okay, great. So listen up, because there are restrictions on the number of minutes that are given. So as Mac explains that, please pay attention.
yes, since there is opposition to this case, each side will be allowed 10 minutes. The appellant will need to reserve a portion of that 10 minutes if they desire to rebut the comments of the opposition.
We're going to hear from Metro first about the facts of the case, or their facts of the case. When the time comes, you just heard that instruction. There's 10 minutes total for you and anyone who wants to speak in support. But don't feel you have to use all of it, number one. And number two, save some of that time to rebut what you hear from those who want to speak in opposition. Because if you use all of your 10 minutes up front, you'll have no opportunity to rebut. Cool? Great.
All right, this case 2024-033 is 2688 Miami Avenue, Craig O'Shoney, and Representative Chase Leatherwood of Chatty Property Management. The permit application was denied. Metro contends the short-term rental property is not the principal or primary residence of the owner or appellant. It's an R15 zone district, which allows only owner-occupied permits. This is governed by BL 20-187. However, the board has discretion under BL 2023-136. I apologize, you have a typo on the first date on your case summary to the board members. It's January 28th of 2020. The appellant acquired the property at 2688 Miami Avenue. According to the notes on the building permits obtained for the dwelling by the previous owners, the building was approximately 25% complete. September the 4th of 2024, an owner-occupied permit application was submitted. On September 5th of 2024, Inspector Nicholas Owen began the process the application. Included in the application package was a proof of property tax payment document from the Metropolitan trustee that listed Mr. O'Shoney's mailing address as 4760 St. Andrew Court, Clarksville, Tennessee, 37043. Inspector Owen, Inspector Owen referred the case the application to Inspector John Phelps to investigate. Inspector Phelps found that the deed for 2688 Miami Avenue lists Mr. O'Shoney's mailing address as 4760 St. Andrew Court, Clarksville. The Metro Assessor of Property's property record card for 2688 Miami Avenue lists the owner's address as 4760 St. Andrew Court, Clarksville. Inspector Phelps confirmed the Metropolitan trustee lists Mr. O'Shoney's mailing address is 4760 St. Andrew Court in Clarksville. Mr. O'Shoney's driver's license go to 4760 St. Andrew Court. Mr. O'Shoney's voter registration goes to 4760 St. Andrew Court. Mr. O'Shoney has a UCC document filed with the Secretary of State which lists his address as 4760 St. Andrew Court. Mr. O'Shoney has a vehicle registered at 4760 St. Andrew Court. The vehicle was last registered on June the 30th of 2024 for the next year expiring on June 30th of 2025. The 2024 tax year for the Tennessee Assessor of Property in the Montgomery County Trustee's Office lists the owner of 4760 St. Andrew Court, Clarksville, Tennessee as Craig A. O'Shoney with a mailing address as 4760 St. Andrew Court, Clarksville. On September the 9th of 2024, Inspector Owen emailed the property management company, Chatty Property Management, which had submitted the permit application on behalf of the appellant. Inspector Owen informed them that the application was denied for lack of primary residency. On September 24th of 2024, the appeal was filed. The appeal was originally scheduled to be heard at the November Short-Term Rental Appeals Board meeting. On October the 24th of 2024, I began to review the case file for the appeal. This was the day following the October 23rd, 2024 appeal board meeting. While reviewing the permit history for the property, I found the new residential building permit had not been issued the final use and occupancy approval and letter. The short-term rental permit cannot be issued to a property that does not have a final use and occupancy approval and letter. Therefore, the short-term rental Board of Appeals could not hear the appeal case for the property that was not eligible to obtain a short-term rental property permit. October 25th of 2024, I asked short-term rental property administrative assistant Alicia Buffer to inform the appellant that they had to obtain the final use and occupancy approval and letter before the board could hear the appeal. As a result, the appeal was moved from the November board meeting agenda. October 29th of 2024, the final use and occupancy approval was signed off and the letter was issued. I continued to investigate the primary residence of the appellant and found the following information. Mr. O'Shoney was quoted in the August 3rd, 2022 Fox TV, Fox 17 news story about Metro parking meters as follows. In quotes, Clarksville resident Craig O'Shoney says, I do carry coins. I actually do spend real money. I don't carry cards. Mr. O'Shoney is a licensed insurance agent with licenses in Nevada, California, Louisiana, Illinois, Ohio, Texas, Georgia, Kentucky, Minnesota, and Mississippi. Each of these licenses has an address of 4760 St. Andrew Court, Clarksville. Mr. O'Shoney's LinkedIn page lists him in Clarksville, Tennessee. December 6th of 2024, the United States Securities and Exchange Commission Investment Advisor Public Disclosure website, which is an official website of the United States government, has Mr. O'Shoney's address as 4760 St. Andrew Court, Clarksville. On page 5 of Mr. O'Shoney's IAPD report is where that address is found. On page 2 of the pre-report explanation, it contains the following information, and I'll quote, "How current is this information? Generally, representatives are required to update their professional and disciplinary information within 30 days. The Tennessee Secretary of State lists an LLC, which became inactive on June 17th of 2024, where the principal office and mailing address is 4760 St. Andrew Court, Clarksville. This LLC is also trademarked and registered with the United States Patent and Trademark Office, and the current owner is Craig O'Shoney, with the address listed as 4760 St. Andrew Court, Clarksville, Tennessee. That trademark is still active. Based upon the information found online, Mr. and Ms. O'Shoney own and operate a fitness center called Fit Shop 24/7, which is located at 1879 State Highway 48 in Clarksville. Ms. Lori H. O'Shoney's Tennessee driver's license is registered to 4760 St. Andrew Court. Ms. O'Shoney's vehicle is registered to 4760 St. Andrew Court, Clarksville, and her voter registration is listed at the same address. November 11th of 2024, an email complaint for the property at 2688 Miami Avenue in response to the required neighbor appeal notification letter was sent to the STRP questions mailbox. It stated that property should not be eligible for an owner-occupied permit, as it is not the owner's primary residence. Our department received 3 notarized affidavits from residents on Penmead Way, which is a street directly behind Miami Avenue. All 3 are in support of the zoning administrator's decision to deny the owner-occupied short-term rental permit.
I think just for fair balance, Mac, did we not receive one from a real estate agent who said she was writing in support? Just want to make sure we cover all the bases.
We did. In
Okay.
fact, we received 2.
2, okay. And one was from, I noticed, a real estate agent, and the other was from, did I miss that in here? Oh, it was a separate email in support? No?
It was a neighbor.
Okay. And was it included in this packet? I'm sorry, I missed it.
It should be in your packet.
Okay,
yes.
my apologies. So 2 letters in support. Got it.
I have a question for the city.
Before we hear from Mr. Hargis or from the appellant, I think Terrence has a question.
I do. I have a question for council. Just looking at the facts and specifically facts relative to issuance of the occupancy letter, is this appeal properly before us? And the reason that I ask that is because at the time that the appeal was filed, the appellant could not lawfully occupy the premises. And so that means that the information upon which the permit was even considered is faulty because you didn't have a legally occupable residence at that time. So looking back to that date, would that mean that the permit should have been rejected, or the permit application should have been rejected at that time had those facts been known?
I think that's why they deferred it, and I'm going to ask them to speak to their normal practice of what they do. Has this come up before, Mac, in situations where there wasn't a UNO, or was this the first time that it's actually come up?
This is the first.
So I would say, to your point, I think one option would have been just to deny it because you can't do a short-term rental at that point. But I also think deferring it until they get a UNO probably cures that, because they were going to get the UNO anyway, right?
They were. I think that it matters if no person can apply for a permit who's not legally eligible on the date the application is made.
Right.
And under no set of facts would this appellant have been eligible on that particular date. So the appeal sort of becomes an extraneous question. Whether there's a right to file an appeal becomes an extraneous question because the issuance of the UNO cures the issue with as far as your ability to file a permit application in the first place, not your ability to file an appeal.
Right, and if we walk it through, though, let's say we go the path that that you're sort of asking us to walk down, let's say we denied it,
Right.
then you would have had, what, a time period to reapply?
Yeah, you would have been eligible to apply once you have the UNO letter, because then you could lawfully occupy the premises.
So that's kind of where I'm going. I don't think that there's an incurable issue
Okay.
by the delay, but I understand what you're saying. I think what you're saying is, if it is completely accurate, that it could have been that way. You could have denied it. But I think to Mac's point, and the reason why he deferred it is because he knew that they were very close to getting the UNO. So they just would have refiled anyway. I don't, and Joey, do you?
I believe Joey.
In my mind, you would have rejected the application altogether.
Well, and I have a, I think we, sorry.
Let's hear from Joey before we go down a rabbit hole.
I think I know what he's going to say. He's going to tell us we have to consider the facts that you had on the date that the application was
Why
filed.
don't we let Joey tell us what he's
Actually,
going to
no,
say?
not in this case, but yes, I would remember Williams tell you that. This one, I just do want to address what you brought about, Mr. Bond. That was the reason for the deferral. We do have a final UNO. Oh, yeah, I'm sorry. Max reminded me to identify myself. I am Joey Hargis. I'm the Metropolitan Zoning Administrator and work in the Codes Department. The short-term rental department or sub-department is an entity that falls under my jurisdiction. And so that Mac and his crew staff this board and review applications for it. Give you one behind the scene. Let me address Mr. Bond's point first. And that was the reason for the deferral. And because it's the first time it's really appeared before y'all, we occasionally get these in the Board of Zoning Appeals realm. Now, ours are typically appeals off a denied permit application or a denied permit or a revoked permit. There's usually something, there has to be some present case or controversy, to get there. And the curing of that in this case is the final UNO that was issued on October 29th. By our department for the house to be occupied.
So we consider that retroactive to the date of application.
The deferral, in my mind, we just shift it, to deferral to make sure that, and the reason for all of the filing deadlines so that notice can happen, so people know to come to the hearing, so it's properly advertised, and that's what I'm submitting to you guys. That's been done. The deferral cured any issues with notice that may have been a bit premature absent the UNO. Now that we do have a UNO on October 29th, the subsequent notification of neighbors to this hearing today in December cures any issues that we have.
Okay, I don't want to beat a dead horse, but I just want to make sure, because when we say things in a meeting, obviously it becomes part of the public record, and I don't want someone to cite to this meeting to avoid a step that they would otherwise have to take. So we're saying that a person without a UNO license could file an appeal on a denied permit.
No,
and then as long as they,
I've directed my staff to be certain before we schedule, before we even take the appeal, that they have a final UNO. This one didn't get called.
so this is one that slipped through the cracks, essentially.
It is. And
Okay,
that's
wanted to be certain we're not
was a
setting
learning
precedent.
Yes, sir. Making sure that it's properly in front of you. And to address Ms. Williams' point, I would say that I do want to address you guys to give you a little bit of behind the curtains of how we get here. Me and my staff meet weekly, sometimes bi-weekly, depending on the level of applications and things. Obviously, I provide staff the opportunity to review cases and on their own. They know from my direction, you guys don't need to necessarily come to me for denial of this one. This one's obvious on its face. But in instances where we get into residency and stuff, we always sit down and talk about them. And just in this case, and I'm appreciative, I know that the applicant, Mr. Oshoni's not present, his representative's here, and I don't expect to impute on him knowledge that he may not know. But for us, I just want you to look back and listen to the facts of everything that we weigh. Where does this gentleman reside? For an owner-occupied, it has to be your principal residence. For our new member, Mr. Simmons, he may not have heard one of these before. Remind him that spouses, be they husbands and wives, two men, two ladies that are married, in my world, have to live at the same place. They just do. It's nowhere in the law does it say that, but that's the ground rule for this. Otherwise, if I had it, my spouse had a permit before we were married, when we get married and move into our joint domicile, one of us is going to have to give that permit up, okay? Now, that's not the situation with this gentleman here, but I just want you to understand some key ground rules that spouses live together in the same residence. They just do. That's the only way this permit system works without fraud. For some ground rules in that. When my staff brings to me a list of driver's license, LLC documents, voter registration, car registration, it doesn't make sense to me that my car should be registered in Montgomery County if I live in Davidson County. Okay, there could be some overlap when I first moved, but generally at some point, it's time to clean that paperwork up. Again, I shouldn't have voter registration in Clarksville if I live in Nashville. We look through deeds. We look through any public available data to see that these folks are turning into us. But this really, I come to speak today, not only to this case, but future applicants too, to understand that what we're looking at. I sit there and I take those documents and I start laying them out on the table, and I'm kind of weighing things like, well, that's in his favor. That's what, no, this is kind of, and at the end of the day, I'm looking at, I'm not supposed to believe my eyes when I see 18 documents that say I'm in a different location, and I've got just his personal statement that he lives on Miami. I'm not buying it, or that husbands and wives live in different locations. Just, I can't agree to that. So those are denials that you're going to get from us, and it's just a make statement. One for Mr. Simmons, helping this is first board meeting at least that I've attended. But to understand kind of where we're coming from. Think about the scales of justice. I'm kind of weighing the evidence on one side versus another. I will tell you, in the event of a tie, my ground rule to my staff, tie goes to the property owner. Tie goes to the applicant, because the applicant should get, if it is 50-50, I'm going with the applicant. There may be, iffy testimony one way or the other, but if in our mind it is an even swap, I'm going to defer to the applicant and grant a permit.
So I have one question. So is this to say that an occupant should not apply for a permit until they've taken residency of the home?
That would be my advice, yes, sir. I mean, be sure, once you're fully moved here.
That's why my question.
Yeah, if we're in the process of moving from Clarksville down here, great, get done moving, then apply for your application.
I don't want to do a disservice to the appellant of kind of negotiate, discussing this case without having heard from the appellant. I think it's a great question, Rona. I think we've covered that in the past, and we've also had situations where people perhaps had the best of intentions that they were going to move from Alabama to here, and we're supposed to take that on faith, even though their kids are registered in school down there and they're sophomores. That is. These kinds of situations do get presented to us, but I think it's only fair that we let's hear the man out, and let's hear what the story is. And
Could I ask a question about the facts that Metro has provided?
Yes.
Okay, great. Thank you.
of course,
Did the applicant reapply for an STR permit after they received the final UNO? I'm not asking about did they file the appeal, did they defer, did they reapply for a permit after receiving the UNO?
Get you.
The information on the permit is good for 90 days. Technically, what they did is just resubmit the same application, because we can't, all the documents are good as long as 90 days is not expired. So they just resubmitted the application and were denied based upon not primary residency.
When did they resubmit the application? Because I didn't see that in any of the documentation.
It was resubmitted after the use and occupancy letter was received.
Okay, well, that answers my question.
I just would love to know the date, because I didn't see anything about a resubmitted application. I saw a deferral of the application for an appeal.
It was basically just a formality. Once they, once they provided the use and occupancy letter, the application that they had on file was technically resubmitted because all that information was still current and good. There was no information in there that we could deny, and so therefore, based on it being outdated or changed, so then we just denied it because it was not the primary residence.
So, Matt, would
It was more of a formality.
understood, but would it be fair for Nicole's point that we could assume that the application was resubmitted technically, officially, by
Yeah.
design on October 29th, in line with the final use and occupancy?
Exactly.
Okay, so October 29th, we will consider it resubmitted.
By virtue of Metro's action, not the appellant's action, though, right?
No. When the appellant provided the use and occupancy letter, they said we were reapplying.
Okay.
Okay. All right.
Perfect.
Okay. We're going to get to you in 2 seconds, and you've been so patient. Thank you very much. Are we good now?
Any questions for me? This is my only time to speak. So.
I'm good.
Everyone good?
Yep.
With
Thank you.
Mr. Hargis?
Need to get to my date.
All right. This has been very unorthodox. Sorry. Let's hear from the appellant, and keeping in mind, despite the fact that this just took like 20 minutes, that we still have to watch the clock. Okay.
Well, I'm gonna say, when we reapplied, we submitted.
Could you just turn your
Yeah,
mic?
oh, I'm sorry. And by the way, my apologies. I should have instructed you to give us your name and your address for the record, and then off you go.
All right, my name is Spencer Sweat. I'm with Chady Property Management. Do you need my address or our company's address?
I would like your address.
1128 Greenland Avenue, Nashville, Tennessee, 37216.
Great.
When we reapplied, we submitted new documentation of his address being changed on multiple documents that he was in the process of changing. So he changed his driver's license when he got his UNO, because like Mr. Bond said, he couldn't live at the property without the final UNO. So that's why all of these dates on here, his address was in Clarksville. He does have a home in Clarksville. That's where he's living now. But now that we're starting he got all his furniture moved in. We did resubmit. We did submit the application too early, but he is in the process of moving everything, all of his stuff in his Clarksville home. This will be his primary residence. He does go out of town a lot. That's why he's not here today. So when he's out of town, he will be staying at this property on Miami Avenue. So our biggest point was all these dates where it said he lived in Clarksville, he did live in Clarksville, but once all his furnishings and the final constructions, there's a few minor things. We submitted the application early. That was our fault. We should have waited until he moved in. But this will be his primary residence, and when he is out of town, that is when he's going to be renting the property out.
Thank you very much. Does anyone have any questions?
Yeah, I do.
Go right ahead.
Okay, so you said he does have a home in Clarksville. That's where he's living now. This will be his primary residence.
Yes, once he gets everything moved, once all the furnishings are done and
Got it.
everything the house is finally decorated.
Thank you.
And that'll be before the end of the year.
Terrific.
Got it.
All right. Any other questions before we hear from anyone who wants to speak, either in support or in opposition? And you'll have time to rebut because you've kept your remarks so brief. Great. So for those who want to speak does anyone want to speak in support? No? Does anyone want to speak in opposition? Don't fight each other for it. There you go. Come on up. Yeah, go have a seat, sir. Thank you so much. You're going to come over to this chair.
Okay.
And you heard the instructions. You have 10 minutes total. Please don't feel like you have to use them all. You're going to give us your name and address for the record and tell us about the situation.
Yep. So name is Iman Bagger, and I live at 2690 Miami Avenue, to the left of Mr. Craig's property. I've lived there 4 years. I work remotely. I haven't seen the dude there more than twice the entire 4 years, and it's probably been 1 or 2 years since I've actually seen his face, and that's when he was walking me through the property. I don't think he has any intention whatsoever of moving in there. I think he set up for an Airbnb so that he could rent it out when he realized he wasn't going to be able to sell the property. What I can tell you is that I've never been so involved in somebody else's property in my entire life. This is the facts speak that he just is not going to live there. He has no intention of it. I'm shocked there'd be anybody in support of it, bluntly. But beyond that, there's going to be a lot of other residual things that I'm going to have to deal with. For instance, waking up and dealing with a dumpster in front of my house where I can't actually leave my property. That's happened multiple times. My yard has been torn up by Metro Water because this guy can't, for some reason, get water and plumbing down correctly. 3-4 times this has happened. And this is just the times that I've documented and started realizing the numerous amounts of issues that this one person has caused. I've actually reached out to some of the local property folks that, was essentially licensing or giving him permitting on this home because it's been under construction. We moved into our home in 2018. I think a previous builder started working on it. He bought it in 2020. I mean, this thing has been under construction going on 6 years now. I'm glad it's finally done, but I can tell you 100% this man has no intention of moving in there. He's not living there today. It's not set up with any sort of permanent furnishings. It's set up for an Airbnb. Yeah, that's all I have to say.
Thank you so much. Before you run away, does anyone have any questions? Okay, now you can run away.
Okay, thank you.
Sir, if you wanted to rebut, I believe you've got time left.
Is there anybody else from opposition seeking?
Yeah, did anyone else that was here in opposition wish to speak?
We do. And
Oh,
if we
okay.
could remind them that it's a shared 10 minutes.
Yep, sorry.
All those in opposition.
When you were all battling to not speak, I thought that was it. So again, we have 10 minutes total.
I'll make it short.
And I think there are about 8 minutes left. Don't feel like you have to use it all.
Okay.
And if anyone else wants to speak up now so that your colleague here knows or your neighbor here knows to
I'll make it brief.
Okay, super.
My name, Marianne McLean.
Okay.
I live to the right at 2686 Miami Avenue at Nashville 37214. We received the letter from Mr. O'Shoney beginning of November that was stating that he had made the appeal. If we had any questions for him, please contact him. It was his intention to have it as a rental, and that if there were ever any problems with the renters, please feel free to reach out to me and I will get back to you. Well, we did exactly that. We reached out to him. I sent him an email on November 6th. And I said, I'm writing on behalf of the neighbors surrounding your Miami home. We'd appreciate a get-together, possibly meeting at your property so that we can give us a picture of what your owner-occupied short-term rental will look like. Since we received your letter, we've spoken with the neighbors, and we all have questions. Mr. O'Shoney never responded, which leads us to believe that if there's a problem with a renter, he's not going to get back to us. So we don't have a lot of faith in Mr. O'Shoney at this time.
Others might have questions, but can I ask, the matter at hand is whether or not this could be considered Mr. O'Shoney's full-time permanent residence. Your neighbor shared with us that he hasn't seen Mr. O'Shoney. Would you concur?
Yes, we have never seen him. The furniture went in. We came back from our vacation in Florida in mid-September, and the house was furnished. Since then, not a single person there. Only workers.
Any other questions? Thank you so much.
No overnight stays there for sure.
Thank you, Ms. McLean. Anyone else want to speak in opposition while there's a little bit of time left? Go right ahead. And don't forget to give us your name and address for the record first.
I am Kerry McLean. I live at 2686 Miami. And on behalf, I just want to mention that to the left, our friends have a 7-year-old daughter. And to the right, our friends have like a 8-year-old son. And I don't know what the boundaries are, when it's A, B, and B, I just don't know what that is as far as predator-wise. Do they have any of that, type stuff through the A, B, and B stuff? And I know there's been some troubles on some other houses that were A, B, and Bs down the street. So we're just totally opposed to this. And I think that when they put the furniture in, it was set up like it was A, B, and B furniture. So
Meaning like bunk
Airbnb.
beds?
I'm sorry.
What do you mean by Airbnb furniture? Like bunk beds?
Yeah, I mean, I've built probably 4,000 houses in the Nashville area. And, my wife is a realtor, and we got opportunity because we was like, if this is an investment type thing, and if it gets to the right monies, we might be interested in purchasing it for our son. So we actually went through the house, and it is designed nowhere near for an Airbnb. I mean, you go in, it's one level, kitchen, living room, then you go up to the baths. So if he was ever going to share it as that, then that wouldn't work.
I'm so sorry. You said you were curious that it may be an investment property for you. Was the house on the market at that time?
It was.
Okay, and that happened this fall or this. Okay, I believe I remember that.
So we was looking up and down
literature.
the
Thank
street
you.
for a house for our son to live
Got
in.
it.
And so at that point we was just trying to see what was going on with it, but it was a little overpriced for his price range. So we just kind of left it be, try to see what else was going on. But that's all.
Thank you so
Thank
much.
you.
Anyone have any questions before we let Mr. McLean go? Okay. Anyone else? Okay. How much time do we have left for opposition? 5 minutes.
Okay. All right, I'll make it pretty quick. My name is Danielle Baggern. I live at 2690 Miami Avenue. I guess my husband and I, he's already spoken. We've been living there since 2018. I've been working there remotely since 2020. So over our entire residency there, at no point has anyone lived in that house, let alone Mr. O'Shoney. And so if the fundamental fact of it is he's applying because he is currently owner occupied living there, like that is a false statement. And so everything else aside, that is false. That's all I have.
Short and sweet. Thank you so much. Does anyone have any questions? Thank you so much. Alicia, can I ask how much time we have left? 4 minutes. Okay. Yeah, I'm sorry, not for opposition, for 7:50. 8:23. Do I hear? No.
I'm not gonna need that much.
Okay.
So I just want to go over a few things. The second lady said she's only seen workers. That is correct.
Okay.
There's still work going on in the house. That's why he can't live. He hasn't officially moved in yet. We did prematurely apply. He is getting all of his addresses changed. He will do that if we have to resubmit the application. Mr. O'Shoney is going to live at that. It's going to be his primary residence. One of them also said they've only seen Airbnb furnishings. This is going to be an Airbnb. It's going to be an owner-occupied one. So there are furnishings in there that are for an Airbnb. And then we're going to reapply. He's going to live in this property. We will resubmit all the paperwork that needs to be resubmitted. He's changing all of his addresses. His wife is changing his addresses. His son is going to live at their Clarksville home. He is going to live here. There's no facts showing that he's not going to live in this property. I don't think anybody can prove that he's not going to live. If we have to submit our calendar every month that shows when it's not occupied and when he's there, we can do that. This is going to be his primary residence. And then I know some of the emails talked about some things that have gone on with Airbnbs. So Shady Property Management, we manage over 100 properties all across the Southeast. We put noise detectors in every property. We have a one-strike rule. If a guest breaks the rule, their stay is canceled and they do not get a refund. We do guest vetting, so we make sure that everybody who's staying at the property is there for the right reason. We don't let any in-city, if you have an address in Nashville or surrounding areas, we do not let you stay at one of our properties because those are the people that throw parties. So, and again, with those 100 properties that we have, we rarely have an issue because of the checks that we do and the systems that we put in place. For all of our properties have Ring cameras. We can count how many people are coming in and out of the house. We have a full team that monitors that. So when it comes to that, because I know there were some emails with that information in there, we take care of that and we make sure that the property is managed properly and the neighbors will be happy with the guests that are there.
Very good. Any questions? Thank you so much for your time. We're going to consider the public hearing closed. We're going to discuss this amongst ourselves. So unless we reopen the public hearing and ask anyone to come back up, there will be no more opportunity for you folks to speak. Okay? So thank you so much for all your time.
Could I?
Nicole, please go right ahead.
Okay, he doesn't live there. His representative very plainly stated that he does not currently live there. It doesn't really matter for the purposes of this appeal whether he will live there. The fix for that would be a reapplication, not an appeal of the denial. So I think this is incredibly straightforward. If it's okay, I just want to make a motion that we uphold the zoning administrator's decision to deny the permit.
And I second. It is seconded multiple times. It is seconded and third. I couldn't agree more. So shall we see a show of hands to Nicole's motion that the zoning administrator did not err? Very good. It is unanimous. Thank you so much for your time today, everyone. And thank you to all my fellow board members for the time that you've committed this year serving our community. And to all of you guys for all your hard work at Metro. We are adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.